Morning, afternoon, something like that. Let's see. Before I begin, I want to thank our sponsors today and FIBA. I always enjoy these seminars as I enjoy working in this industry. I also want to acknowledge the members of the Forms Committee, current and past, who've helped in the development of our documents. Paul Flannery, John Burkhart, George Jousma, Rob Moss, and Chris Anderson. All of them have invested a great deal of time in developing these documents and in advancing the interests of our industry. It's not easy to work with a bunch of opinionated perfectionists, but we put up with each other, and the committee pushes on. I also want to thank our associate, Stephanie Klein, who helped me put together this presentation. So the subject is purchase and sale agreements, FIBA, MIBA, and IYBA. Here's the deal. When you start dealing with bigger boats, you have to come to grips with the existence of a contract known as the MIBA, MOA, the Mediterranean Yacht Brokers Association, or formerly known as that. And historically, it's been the dominant contract in the big boat business. But that's changing. It's changing because of the work of FIBA. And it's going to change more when the name of the organization gets changed to the International Yacht Brokers Association. It's going to change for two reasons. One is ours is a better contract. It's a better contract because it's more attuned to the financial realities of today. And what do I mean by that? The MIBA contract is a very seller-friendly contract, and it has traps for the unwary that favor a seller. And it is specifically the product of a time when people stood in line to buy big boats and people were buying production slots at the big yards. Those are the big boats, right? More or less. Not that big. But anyway, if you look at what this book, which is kind of the Bible for yacht lawyers, it's called The Law of Yachts and Yachting, and it's written by Filippo Lorenzon and another guy who's the principal author of the MIBA contract. What it says is that, I can't read it from here. To a practitioner more familiar with the straightforward inspections and other contracts, the conditions survey arrangements may appear convoluted at very least and not particularly attractive from a buyer's perspective. However, at the time when the 2005 edition was published, the large yacht market was rapidly expanding, and with a strong demand for new and used vessels, it was very much a seller's market. Conditions have changed dramatically since 2008, and with fewer buyers in the market, it may no longer be as acceptable for a buyer to have such a restricted right to reject a yacht following a condition survey. And so they continue to talk about how they might change it. But here's the deal. When we updated the FIBA contract, we changed it. We have a contract that doesn't have those issues. Secondly, the dominance of the contract relates to some extent, the presence of Russian and Middle Eastern buyers in this market. and they are diminished, particularly now. This is even post-2008. There's more American buyers, there's more Latin American money. And ultimately, whether it's Latin American or Russian, it depends on sophistication really, but money talks and sets the rules. And that means buyers get to set the rules. In conventional contract negotiation, that's elementary. And when you have a buyer from this hemisphere who looks at a contract that says disputes are going to be governed by English law, they're going to be resolved in England, and they're more complicated, the contracts, than they need to be, you're going to find out that, or I think the Europeans are going to find out more and more, that unless a buyer is desperate for a particular yacht, or there's an opportunity that requires amoeba because you have a bunch of people looking at the same yacht, or you're dealing with a European court that has possession of the yacht, and they're not going to deal with anything other than something that looks like amoeba or a European bank. Unless you're dealing with that situation, the FIBA agreement is working, and it is being used. It is being used on the purchases of yachts in Europe by people from the Western Hemisphere. Now, this is what they look like. Not that it's particularly relevant, but just to give you an idea, there's the FIBA, the IYBA, and the amoeba. But take a look at this. This is of some relevance. The IYBA agreement is 4 pages. The amoeba agreement is 8, and the FIBA agreement is 4. Now, the amoeba agreement comes with a 2 or 3 page addendum as part of the standard package. It's kind of a preloaded addendum. You're the yacht broker. You want to understand, you want to have read the contract that you're asking your client to sign. It's a bit easier to read a 4-pager that's written in American English that you use on your regular transactions than it is to read a complicated agreement written in UK English. It's just easier to work with. Now, there's you got 8 pages. Here you got 2 more until you go down the next page. And so it's not really a big deal, but on a practical level, it's a big deal to have to deal with complicated documents. One of the things that we did in our forms committee is we wrote these documents in a language that people could understand as much as possible. And we probably can do an even better job. But they're understandable. You guys work with them, and there was resistance to changing this agreement. But it works, and it's understandable. Now, if you're dealing with amoeba, not only is it 11 pages, but in this book, there's 24 pages in the chapter on the MOA, and there's 84 footnotes, and I already cited footnote 61. Now, references to size aside, since this isn't a presidential debate, there are other major differences. And my focus is primarily on FIBA and amoeba and a little bit of IYBA. But a few preliminary remarks. Reading these agreements is tedious. It's kind of boring. It's actually hard to stay awake sometimes reading them, which is why it's good to hire a lawyer. Generally, lawyers are very boring people, but they actually enjoy reading this stuff. They enjoy it more if they get paid for it. But from your perspective, if your client hires a lawyer and something goes wrong, you've got somebody to blame and it didn't cost you anything. It's a pretty good deal. You're going to hear me say this at every single presentation I make, but that's just the truth. Now, just a quick review. I put this together yesterday. I didn't have time to get pictures of everybody, but these are the law firms that we deal with and the characters that we deal with in our firm on a regular basis. And these are the characters that we deal with here on a regular basis. And if you're not pictured, I apologize, but I put this together sitting on my floor at home yesterday. And these, you know, what they have in common is generally they're very boring, with one exception. In the top left-hand corner is Michael Moore, and I recommend him to you if you need a master of ceremonies for any event, your favorite charity. Michael's the guy to call. The rest of us are kind of boring, and including the people in my law firm. It looks like we're having a good time, but we're just faking it. I told everybody to smile. Now, the ultimate issue in any contract, and the most important issue for you guys, is, you know, who cares about law, where it's going to be decided? Am I going to get paid? Okay? As I was telling somebody at lunch today, the most important in any thing in any deal is not whether the boat gets sold, it's whether you get paid. Because if you get paid, the boat got sold. But if the boat got sold, you may not get paid. So that's part of what we are working on in this FIBA agreement. And sometimes we get some criticism, well, it didn't consider this or it didn't consider that. Yeah, well, it's true. We have to balance a lot of things, but what we're trying to do is get you paid. Still, we want criticism. We want to improve it. On a practical level, though, if there's a commission dispute and you got an IYBA contract, where's the dispute going to be settled? You want to pay a London lawyer, you think we're expensive? Okay. So fight like hell. If you've got a buyer, you tell them, man, put that money in my account because I'll protect you. It's true. And if somebody else has got the buyer and they're from Europe or someplace, you tell them, man, you put that in my account because I will protect everybody. And the courts here are very efficient. You basically have to talk out of two sides of your mouth. But the bottom line is, in an international deal, the best protection, you heard this expression, possession is 9/10 of the law. It applies particularly in commission disputes. Okay? In the IYBA, what happens? Well, our paragraph, our FIBA says, our paragraph 14 says, a broker can retain the commission. Now, if I'm wrong here, I would respectfully request that Rob and Michael point it out later. Not right now. I don't want to be embarrassed. But my understanding of the IYBA, and I read it again yesterday, is the proceeds go to the seller. And I told you about, I think last time, that I had a deal recently with an American broker and a Russian seller, and one of those European law firms up there told me, well, we're going to give the proceeds to the seller, and the seller can pay your commission. And my client said, right. And I had no option. You know, what was I going to do? I mean, the contract said what it said, so I did what lawyers say. I said, I'm going to sue you, man. And I'm going to sue your law firm, I'm going to sue you, and you don't want to be sued in the United States. And so we got the money. He later told me that I had made a mountain out of a molehill, and it was not really a big deal. It wasn't his money, and he wasn't going to have to chase anybody. I'd like to fix our form a little bit so that we can maybe, if the escrow is held by a lawyer, we can direct the lawyer to do that as well, because sometimes that happens. Another issue relates to the deposit. The three questions are, when is it due, how much, and what happens if it's not paid on time? A couple of them are simple. I mean, we say 3 days, but you can fill in the blank. You can say 3 days, or many want you just put your pen down there and write in how many numbers, whatever number you want. And what percentage do you put? Same thing. In the IYBA, it's a standard 10%, a standard 4%, and you want to change it, I guess you can write it out. There's no place to do it, so you use an addendum. just a little more, when it's fixed in print. When I write agreements for my manufacturer clients, I put it in print and I make it look like it, you can't really change it because it's the standard form, right? Well, the IYBA is kind of a standard form that people try to tell you you can't change that much, but you can change anything you want. But the FIBA makes it easier, okay? Now, let's talk about what happens if the deposit is not paid on time. All right? Now, you've heard it said from this podium or similar podiums, there's no deposit, there's no deal. Well, I'm telling you, there's no deposit, there's a deal. Take it to the bank. And the reason there's a deposit, there's no deposit and there's a deal, because guess what? The FIBA contract says, no deposit. You don't make that deposit, buyer, the seller can sue you and get attorney's fees for it. So you got that bozo the clown signing contracts all around the show. He's not doing that anymore. Now, how does IYBA deal with this? Well, let's look at what English law says, and it's up on the slide. English law says, blah, 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 if for any reason whatsoever, but that's the wrong slide. Okay. In that case, a binding contract was concluded, and the deposit was never paid. When the buyers failed to pay the deposit, the sellers treated such failure as a repudiatory breach and sought to recover damages in the amount of the deposit. Okay, so they signed the contract, they didn't pay the deposit, seller sued, said, give me the deposit. In deciding in favor of the sellers, the Court of Appeal held that the provision for payment of the deposit was not a condition precedent to the formation of the contract, was a fundamental term of a concluded contract, the Blankenstein case. But what does IYBA do? We at FIBA give you a right to sue for that money. But IYBA does it a little different. What they say is, notwithstanding what the law says, you can sue, the seller can sue for provable losses and expenses reasonably incurred. That's in paragraph 31. So good luck to a seller getting provable losses because the dude didn't pay the deposit. You know that that dude just diminished the value of your boat if you took a low offer thinking you were going to get it sold. How are you going to prove that? Who's going to make the money? The English lawyers. That's who's going to make the money. So you want to stay away from that. We're not going to make the money. The American lawyers aren't. We got to give it to some guy in England. Forget about that. But the point is, over here, we have a real hammer. And the next difference is really the critical difference. All of this is relevant, but the critical difference is this. And we had discussions about how to handle it, but we stuck with this. The buyer doesn't accept it. In writing, he rejects it. You don't accept it in writing, it's rejected. But IYBA tries to stick it to you like that footnote says. So IYBA says, you're going to do a sea trial, and then you're going to do a survey. And you have to do it by the date specified in Clause 9. So, two things. I'll talk about what happens how things should happen. Well, you should do a sea trial way in advance of the Clause 9 date, but then they'll stick it to you. You got 24 hours to tell them in writing that you reject the boat. If you don't tell them in 24 hours in writing, guess what? You accepted the boat. 24 hours. And I've had brokers call me at 7 o'clock on a Friday night. What do? They didn't know. Hey, big boat, big money, sign. No. And you call me at 7 o'clock on a Friday night, I'm telling you all right now, unless you've been sending me a lot of deals, you're going to get a big-ass bill. And I don't want you bitching about it because you're making a really big commission. I had one broker tell me, well, what's the size of the commission matter to the size of the bill? Well, dude, I guess my time on, Friday night and over the weekend wasn't really that valuable, was it? I made that mistake once. And all the lawyers here are good lawyers, and they know what they're doing. You call them because you screwed up, be ready to pay. And especially because you're chicken, because you don't want to tell your client, I should have got a lawyer involved in the first place. Yeah, you deal with IYBA, you get a lawyer. All right. So you got the 24 hours. Okay. And then you've got to do a survey. But guess what? Here, you do a survey, see what you like. But after you do the survey could say, this is the most perfect boat that ever was built. Here, who cares? Your wife came aboard and she didn't like it. Or you figured, man, it's going to cost me a lot more money to fix this up than I thought. Guess what? You don't have a boat. Over there, you got to get a surveyor, but not any old surveyor, not your friend who's a surveyor or who's a captain and who surveyed your 91-foot Benetti, or 92, whatever that Delfino is. But you have to get a surveyor who deals in boats of comparable size and value. That's who you have to have survey it. And they have to tell you that there's a problem with the operational integrity of the machinery or the vessel. What? There's a problem with the operational integrity of the machinery or the vessel or its seaworthiness. Sounds to me like they're trying to stick it to you because you blinked. Now, it gets even trickier if in the real world you got this boat in Europe and you got the Clause 9 date and you're trying to get your Mexican guy over there, but he's got to go to his kid's graduation or something. And, it's the Clause 9 date is, October 15, and he's not there. How long does it take to do a survey on a big old boat? And he's not there for the sea trial. And he wants to go on a sea trial. Well, your Clause 9 date is October 15. Guess what happens if you show up on October 15? You got to reject the boat if you want to have any leverage at all. And nobody wants to reject the boat if there's not that big a deal. But if you don't reject the boat, then you're stuck with major issues. And there's other clauses that give them rights to fix it up and stuff like that. You don't want to mess with that. You got to be careful. And it's even more complicated. Well, I'll tell you about the other complication in a minute. But the Clause 9 date is also the date that they have to deliver you the inventory on the boat, right? And so you're dealing with a sea trial, you're dealing with a survey, you're dealing with the inventory, you got everything going on at once. That's your way out. 24 hours, okay? 24 hours is your only free look period. Here's the language that talks about what kind of surveyor you need to have and what the standards are. All right. I'm going to skip that one. So here's another difference. It has to do with the inventory. Now, we had a discussion of this in the Forms Committee, how we were going to deal with it. Were we going to have an exclusion list or an inventory list? What we decided was The boat's going to have all the stuff on it that it has the day you sign the contract, except for the stuff that the owner says, I want to keep. That's called the exclusion list. And when the buyer gets the exclusion list, they can say, oh, you excluded whatever. You excluded a toaster. I don't want the boat anymore. Right? Guess what? You don't have to buy the boat. Now, English law is exactly the same in theory. But the way they do it is the seller has 7 days not to give you a list of what he's keeping, but to give you a list of what you're getting. And it's a heck of a lot harder to put together a list of what you're getting than of what you're keeping, because there's a lot of stuff on boats. Now, when I say that in theory the law works the same, oops. Let's see what we have. Okay, here we go. On the one hand, the duty to agree on the content of the inventory is clearly unenforceable under English law. But on the other hand, the inventory would only be part of the contract if agreed, dated, and signed, and when no notice of rejection is given, blah, blah, blah. Okay? However, it would seem that a valid rejection of the inventory will not be enough to affect the existence of the contract. In such case, the yacht should still be delivered with all her belongings. Oh. What the heck is that? The bottom line is, if you're working with IYBA, you can have an argument about the credentials of the surveyor. You can, oh, this is really important too. I forgot, but it's really important. Since in a FIBA contract you can walk away whenever you want, it doesn't really matter. But in a IYBA deal, if they disclosed something to you before the sea trial, if they disclose something to you before the sea trial and condition survey, then you are deemed to have accepted it unless you reject it at the sea trial. So they can say, well, the ACs don't work that good, right? Well, unless you reject the boat at the sea trial, you know, you're going to have a question about the operational integrity of the air conditioners? If it was disclosed to you before, you're stuck with it unless you reject that boat. And that's an important difference. And you can have a big argument later in a court in England or in an arbitration in England about whether something was disclosed. And you can have an argument about operational integrity of the machinery. I don't know, I haven't looked at the cases whether air conditioning is machinery, or, you know, I guess the compressors are machinery. Do they have operational integrity if they're not cooling you? I don't know. I don't want to argue about it. So, in simplest terms, really, our contract makes a buyer be serious, but lets them walk. And that's a good place to be on that issue. And then closing a little bit of an art. What do I mean by that? We've had actually a presentation, Michael and I made one a few years ago, about what closing is. And under our contract, it's really when three things happen. When documents are delivered, when the boat's delivered, and when the money arrives in the account of the seller. Now, under the IYBA agreement, it doesn't really say that. It says that all things need to happen, but it doesn't really, it kind of assumes they're all going to happen at the same time. We have greater clarity in ours, and the reason that that matters is that we minimize the risk of lawsuits. All right. There they are again. I don't know why. Must have been late. In conclusion, The agreements are similar in their essence. They're agreements to sell boats, but there are important differences. And when you're dealing with big boats in this hemisphere, you're going to be on a FIBA, most likely. So you're in pretty good shape. And if the boat is listed over here, you're going to be in pretty good shape, because you're going to have a listing agreement that says that you can keep the commission. In the less common case of having a listing on a U.S.-owned boat being sold to somebody in Europe, you're going to have protection under your listing agreement. But it's when you have a American buyer or a Western Hemisphere buyer and a European listed boat that you're at most risk. And because your client's got the money, because you're the buyer, that's when you want to argue. Otherwise, you get into that IYBA thing, and you're going to get squeezed. So I guess my final words are these. I went to Notre Dame. And when I was at Notre Dame, Joe Montana was a quarterback. And I have proof here that Stephanie Klein helped me prepare this presentation, because he is not wearing a Notre Dame uniform. But that is Joe Montana. And when I was there, we used to say quite a bit, "We're number one. We are indeed." Hopefully those days will come back one of these years. They're not happening now. But today, seriously, it's not just because it's the FIBA contract, but we have the best contract. We have the best contract because you are protected and because your clients can read it and understand it. And we're FIBA. We know we're number one as soon as we are the International Yacht Brokers Association. The whole world's going to know it. Thank you very much.
Great presentation. I just want to make one point. In Europe, most brokers feel if the boat's in class, that that's all you need to know, and the survey's superfluous, and it becomes a problem when you try to come up with a defect without the class society agreeing that your surveyor's findings are correct. And over here, nobody seems to care if the boat's in class or not, other than maybe the insurance company. But they put a lot more into classification and being in class, and most boats they're selling are always in class, so you have very few opportunities to get stuff fixed, reduce the price, et cetera. That's my experience.
Well, that's exactly right, and that's why before you sign IYBA, if you sign IYBA without an American lawyer, you want to be darn sure that that's really the boat that you want, right? But every lawyer in this room has an addendum already written to an IYBA agreement. And it has the effect of turning IYBA into a FIBA, which is why you want to hire one of these folks. No, all right. Thank you.